Afternoon, everyone. How are you today? My name is Ben Schwartz. I served as the law clerk to Justice Mary Enos and also as 2022 Summer Pre-Law Program. In case you are not familiar with it, the Pre-Law Program is an educational program that the Judiciary sponsors. It's designed classes that are designed to simulate the first year of law school. Professors from the mainland teach these classes, and as special treat here, we have a returning daughter of this island, the Interim Dean of Rutgers Law School, Cuison-Villazor. Please join me in her warm welcome.
Thank you, Ben, and thank you to the other organizers of the program. Thank you to the Northern Marianas Humanities Council for sponsoring the lecture series. As Ben mentioned, I am Cuison-Villazor. I am the interim co-dean of Rutgers Law School in Newark, New Jersey, and I grew up in the Mariana Islands, in the island of Saipan. It's so good to see familiar faces, people I grew up with, some folks who I worked for when I was in high school, when I came back during college, and then after college. I'm so happy and so honored to come back today, and I'm really enjoying teaching the pre-law program. The students are so incredibly engaged, and so I thank them for their high level of preparation for our classes, and I look forward to our ongoing conversations. Today's talk focuses on critical race theory. It's been in the news quite often. My goal for today is to just provide an overview of critical race theory. So I will lecture on the key tenets of critical race. Okay? All right, so let's begin. So here's the outline of today's talk. First is I will talk about, as I mentioned earlier, just a brief overview, an introduction to critical race theory. Second, I'll highlight why it matters, and that really has to do with the reason why CRT as a movement began in the first place. And then third, explore its application to Pacific Islander issues and cultural rights in particular. And so critical race theory, to provide just a contemporary context, CRT has been banned in the study of it in many different states. In particular, 13 states, Arizona, Florida, Georgia, Idaho, Iowa, Kentucky, New Hampshire, North Dakota, Oklahoma, South Carolina, South Dakota, Tennessee, and Texas, have passed laws banning the teaching of critical race theory in K through 12, and sometimes in universities and colleges. Some of these states have also banned talking about them through the provision of trainings, implicit bias trainings in state and local agencies. Consequences of violating these laws, the ban of CRT in these states may include the loss of funding to the schools and also some other form of discipline to state employees who violate the law. And broadly speaking, 192 bills across the United States have been introduced banning CRT. So what exactly is critical race theory? right? These are some of the books that are popular or conventionally used in teaching CRT. This is the one that I'm relying on for today. I highly recommend it. It's a book by Richo Delgado and Jean Stefancic, and it's written primarily for non-lawyers. I know many lawyers are in the room, but I highlight this is a book that is helpful for understanding it, and it's the key principles, and it appeals to a general audience. So if you want to learn more about this book, please come up to me after the talk. Okay, so beginning with the historical origins of CRT, it really builds on two key movements that happened prior to its development in the 1980s. The first is critical legal studies, and the second is feminist theory or feminist jurisprudence. And so let's first review what some of the key contributions of these two movements. First, with respect to critical legal studies, crits, as they like to be called back in the 70s, 60s, and 70s, challenged the conventional understanding of law. And in particular, critical legal realists have argued that we as in the public law and society, need to engage in a progressive view of the law. A key principle that they argued is that there are no neutral principles in law. No law is actually written in an unbiased manner. Instead, there is an objective that that this particular law is designed to do. Critics have also said that law is biased and indeterminate. This might be hard for some of us lawyers in the room, but there has been this large criticism of laws as biased and indeterminate for quite some time now, and that really stems from one of the contributions of critical legal studies. Law, in particular, according to the crits, have been passed and sustained and to promote hierarchies and to reify and perpetuate hierarchies. All right, so that's on the one hand some of the key contributions of the critical legal studies movement. I'm giving a talking about them with a broad brush, and just so we can get to CRT. Feminist theory, in general, feminism promotes equality regardless of sex or gender identity and gender expression. And so from that perspective, many feminists have argued that laws have been designed primarily to promote men and those who identify as men. And as a result, feminists have argued that there should be laws designed to ensure equality of treatment on the basis of sex. Right? So with these two key movements that were happening in the 60s and 70s came the critical race theory. And how exactly did that happen? Well, Professor Derek Bell, who's considered one of the founders, founding fathers of critical race theory, and Kimberly Crenshaw have asked, and others have asked, where is race in the conversation happening among critical legal studies activists and scholars? When they talk about law is biased or law is indeterminate and law promotes hierarchy, when exactly are they talking about race or cultural rights? So they started asking these questions in the late 1970s and early 1980s. Others also asked, where is gender in those critiques of the law? Why is it that the criticism of the law by the critics themselves have not really centered on how laws have perpetuated patriarchy and the subordination of women? And also in conversations among feminist theorists, some women of color, scholars of color, have argued race is not featured at all in feminist theory. Right? In particular, some critical feminist theorists have argued that when feminists have argued for equality on the basis of sex, that they have not necessarily looked into how those laws have undermined women of color in particular. So, in 1989, a number of these key founders of critical race theories gathered together in Wisconsin, in Madison, Wisconsin, and began talking about what should be the key principles of critical race theory. Here are some of those who attended, and they're considered to be the intellectual founders of critical race theory. Professor Derek Bell, Kimberly Crenshaw, Richard Delgado, Patricia Williams, Mari Matsuda. I believe that Professor Han will be talking tomorrow. I have lecture on Thursday. Some of the contributions of Professor Mari Matsuda on language discrimination. And so she'll be expanding on some of the work and contributions of Professor Mari Matsuda. But these are the intellectual figures and founders of critical race theory. Each of them have contributed to our understanding of what CRT is today. So let me take a step back and talk about what exactly CRT is. Again, in general, from a general perspective, here are some of the main contributions of critical race theory. The first CRT studies and transforms the relationship among race, racism, and power. So in other words, CRT lens looks at the relationship between power and race at the center and how race itself promotes power of a particular group. And here in the critique issued by CRT, and in centering race putting race at the center and examining where power fits in, the argument is that laws have been designed primarily to promote the interests of white elites. And that's one of the key contributions of CRT and what they stand for, what the movement stands for, or tries to point out in examining laws and rules and policies. Second, CRT broadens discussion of law to include other frameworks: economics, history, setting, group, and self-interest, and emotions and the unconscious. In other words, it's not enough to only look at legislative history. It's not enough to look only at the text of the law. It's not even enough to look only at legislative history. It is important to take a broader perspective and look at political and cultural issues that led to the passage of some of these laws and policies that have been adopted in the United States. CRT questions the very foundation of the liberal order, including equality theory, legal reasoning, neutral principles of constitutional law. Among this last part, I want us to hone in on equality theory, the principle of equal protection and equality of treatment based on race, gender, and a whole host of other categories. Among CRT, the view is that equality theory is not enough. The goal of incremental moves to achieving equality or promoting equality theory does not necessarily do complete justice for many other people of color and marginalized populations. Okay, so with those three overviews of CRT, I want to just highlight for you some of the key tenets of CRT. So when you walk away, you can at least say, okay, these are some of the main, the key principles of what CRT is about. First, racism is ordinary and is systemic. That is that race does not have to be explicit. It's not about the individual. It's about the whole system. Doesn't matter so much whether a person, well, of course it matters if a person's racist, but CRT proposes that in order to understand racism, we need to appreciate the ways in which racism has actually been systemic throughout, from the foundation, through the foundation of the United States, through the ways in which laws have been passed in order to promote certain populations only. Second contribution is what's called interest convergence. In simple terms, this means interest convergence refers to the passage of laws. Some laws are passed only because they are in the interest of white elites. And it might also be in the interest of white individuals in particular. And so, in other words, the argument is that interest convergence could be used as a tool in order to try to pass certain laws, in order to, because they promote the interests of white people. And I'll talk later on about how we might be able to unpack that further. Right now, I just want to highlight for you the key tenets of CRT. Third, race is socially constructed. That means that it doesn't matter what our skin color is, Laws were passed to primarily define who is white, who is black, who is a person of color, and underlying all of the social construction of race is the promotion of white supremacy. 4, CRT rejects color blindness. Instead, it promotes race consciousness. Color blindness is one, according to CRT individuals, one that ignores the nuances of how racism has continued to be perpetuated through the years and promotes white supremacy. In talking about rejecting color blindness and promoting race consciousness, it is important to highlight what has been called the black and white binary. That is, in talking about race, some CRT individuals have argued for going beyond the construction of civil rights or of race and equality along the framework of white subordination over black people. In other words, there are other populations of people who should be included in our understanding of race beyond the, sorry, it still works. Okay. Beyond white over black subordination. 5, intersectionality. In talking about race, it is not enough to only focus on race in particular. It is necessary to also engage with how race intersects or converges with gender, with sexual orientation, with class, with indigeneity, and other factors that shape the way that all of us have been socially constructed. 6, anti-essentialism. What does that mean? It means that not all people of color have the same experiences. It means that not all Pacific Islanders have the same experiences. It means that not all African Americans or black individuals have the same experiences, that we ought not to categorize and essentialize one particular view. From a CRT perspective, it is necessary to go deeper and understand what are the specific experiences of that particular individual or that particular subgroup in order to determine how law should be, what issues and what harms they've experienced, and how law might be used to address those concerns. 6, narratives and storytelling. This is a point that Professor Han will be talking about in her lecture, the role that storytelling plays in shaping the law, in coming up with remedies, and promoting equality and racial justice and equality on the base for different groups of marginalized individuals. Last, critical race practice. This means that it's not enough to engage in theory. It is equally important to also practice what one is advocating for. And so critical race practice understands that in order to advance racial justice, gender justice, one needs to actually do the work that it entails, that it requires. Okay, so then, with those tenets, what difference does CRT make? Right? Well, we've talked about how race is socially constructed. From that perspective, when we examine a law, one question that one can ask is, how did this law promote racialization? How did it promote racial subordination? And what do we do about it? How can we undo the decades, if not centuries, of racial subordination of people of color? And here then, one takes a closer look at how laws that were passed to promote white supremacy, so for example, segregation, right, continue to have impact on society today. Maybe that might be through, by looking at public education, funding for public education. We might look at how neighborhoods continue to be segregated, despite the absence of explicit race discrimination in owning property. We might also look at the jury and how juries are selected, and how despite laws that prohibit discrimination on the basis of race in the selection of juries, how that continues to happen. And so there are the CRT scholars and advocates say that it's not enough to look only at what happened in the past. We need to understand how it continues to be reified and perpetuated today in our daily lives. And the third point that I wanted to highlight here, the difference that CRT makes is that CRT gives us language to try to facilitate remedies, the construction of remedies in order to address ongoing harms. Okay. All right, so CRT began, as I mentioned, in the 1980s, but has since been expanded to has other branches now. And here's just a litany of some of them. Critical race feminist, Latino critical, Black crit, queer crit, Asian American jurisprudence, indigenous crits, and within that, the groups that have primarily written about CRT from among indigenous crits are those who write on regarding American Indian nations or tribes and Native Hawaiians, also Muslim and Arab crits, and disability crits or DIS crits. There are many others out there, so this is not a complete list, but I wanted to highlight for you the ways in which CRT has gone beyond focusing only on race per se, or even race and gender. CRT has also been expanded outside of law. As a movement, it has shaped how political studies in political science, in history, in English, in medicine, and other areas. So that's the contribution of the CRT scholars that I mentioned to you have gone beyond the study of law. Okay, so before I move on to Pacific Islander issues, I want to pause and see if there are any questions from the room about what I have said, because I've thrown a whole lot at you right now, and I'm here to give you an opportunity to ask me some questions. And then after that, we will talk about what difference CRT might make in the context of Pacific Islands. No questions? Yes.
Hi, Rose.
Hi, Jane.
So you were saying that it goes beyond legislative history. Do you think CRT is something that is argued in court or argued in legislatures?
Thank you. So in case you didn't hear from those who are streaming, the question is CRT only argued in legislatures, and is it argued in other contexts? Right, if I heard the question correctly. CRT now, at least the way it's been discussed in the political context, has certainly gone outside of the legislature. It's been in front of school board meetings. A lot of parents have been involved in either trying to ban CRT or protecting CRT. Certainly, there are discussions within the legislative space, as we've seen from the states that I highlighted, and in other states in which there have been bills proposed to ban CRT, not only in K-12, but also universities and state and local agencies. I think part of the question here could be why that's happening, right? Why? I mean, I've been teaching CRT since 2007. And it's a seminar, people would sign up, and I think I'm an okay teacher. People sign up usually, and I fill my class, but in the last few years, there's been a wait list for my classes. It's really unbelievable, and I think that has to do with the attention that CRT has obtained in the news. There's a lot of misunderstanding about what CRT is about, and part of my goal here is to dispel those views that CRT is not about discriminating against certain people. It's not about discriminating against white individuals. It's about understanding laws and society, how laws and policies have promoted and perpetuated subordination of people of color. So when we put that into perspective, then we can see why CRT might be happening in churches, in schools and school boards, in the courts, and in the legislatures and other areas that are open to the public. Okay, other questions? So there's a lot here about being uncomfortable, right? About some of the principles of CRT. How it's I've said that CRT individuals, advocates have highlighted that laws have been designed to promote white supremacy. And that's not an easy thing to understand, to accept. And that has generated anger and a very critical response for some individuals. But CRT is not about discriminating against white people. It is about expanding our analysis of how laws were passed at the outset, from the very beginning, in order to undermine the rights of people of color, African Americans, and indigenous Indian American tribes, and other people of color. And so as I then launch into a conversation about its impact or how CRT applies, I wanted to keep that in mind, right? CRT has been described in a way that was to promote a particular view that is not really what the movement is about. The movement is about understanding racism and how to fix it. And there might be differences in how to address the remedies for racism. That's true. That's not easy. Otherwise, we would have been able to figure that out already, right? But the first thing is to recognize that law itself is not unbiased. Law itself, there are no neutral principles in law. Okay, so now I'm going to venture into how CRT has been in the quote mainland a lot, but what relevance does it have for us here in the Pacific Islands? And this is where I'd like for us to be much more interactive. I'd like to hear more about what you have to say. Many of you are actually experts in some of these issues, and so I'd love to hear your views and perspectives. Okay, so just to kind of recap, what difference does CRT make in the Pacific Island context? These are some of the, race is socially constructed, how the laws that promote white supremacy, facilitates consideration of remedies that address ongoing harms. Let's just talk in general about how, in the Pacific Island context, from your understanding of either the CNMI or other island nations, how has race been socially constructed? What are some of the laws that were passed to promote white supremacy, if any? Maybe there might not be from your perspective. Or also, what are some considerations for remedying any kind of ongoing harms on the basis of race? The floor is yours for a few minutes. Otherwise, I'll call on you. I'm going to call my best friend, Dr. G.
Okay. Well, I mean, coming from higher education, one of the challenges we face is really, when we talk about the social construction, is the language, right? And something as simple as filling out a FAFSA, right, where you're given Pacific Islander, and we all know that among Pacific Islanders there are many shades, right? There are many different blends, there are many different types, and that does affect us. Because it is prescribed by law. It is prescribed by the National Center for Education Statistics, which is founded by legislation. And so this does affect us when it comes to whether a census is being conducted, when it comes to awarding Pell funding and scholarship awards. And so, in response to your question, how does it affect us? It affects us when it comes to the language of the law and how that language really limits us to Pacific Islanders. And even just the overall expression Asian Pacific Islanders, right? Okay, so we've got an entire continent, an entire oceanic set of cultures, all blended into one. So, but to go back to your question, I know that it affects higher education in terms of how Pacific Islanders can avail of the many different benefits of higher education.
Thank you. So I heard there a few points. One is that race, going along with race as socially constructed, in the higher education context, FAFSA, financial aid, there are boxes that have to be checked, right? What box do you fill out? And it depends on what questions are asked, what boxes are available. In some states, it's narrow, white, African American, non-Latino, and then Asian, Pacific Islander all into one, right? Where I used to live in California, there are many different categories put there. I was, for the first time when I moved to California, I was able to put in Filipino, right? That's not, in New York where I live, that's not even a box that my daughter in high school can check off. She checks off Asian. And so the categorization of race impacts many different benefits and privileges, and in this case, financial aid. Yes?
And as you know, we're rebuilding right now in state from Super Typhoon U2. And we actually, this matters because we almost lost millions of dollars in rebuilding funds because we had to appoint, like, they were not accepting the data we were giving to them. Like, they were forcing us to choose Pacific Islanders, and I mean, it just got really messy, and we had to make a direct appeal to HUD through their CDBGR grant to understand that it was a lot more nuanced here. Because they couldn't understand, like, how there were many different Pacific Islanders, cultures, languages, even citizenship and residency, and I mean, we had to go all the way to DC to make this case, and I thought that was just difficult.
Thank you. Thank you. Other examples or thoughts about Pacific Islander issues, how race is constructed here, how race is shaped by laws or policies? Yes, Mr. Rivera.
So, and how do we also tackle CRT when it comes to Pacific Islanders voting rights? So, and also like in the cinema, the Article 12. So do we discriminate people here by really, serious about CRT? What are those implications?
Thank you. So I heard you talk about voting rights and on Article 12, and many of you would be much more familiar with the contemporary issues regarding Article 12. My work on Article 12 is dated now to the late 2008 and later. And so I would actually really appreciate to have an engaged conversation about it. But I hear you talking about, in general, right to vote. Who gets to vote on a particular issue? And that raises questions of democratic principles, right? Who gets to participate in the democratic process? And who gets to vote on an issue, on a law that is designed to protect certain groups of people as articulated through the CNMI Constitution? And who's left out of that conversation? Who's left out of the ability to vote? Mr. Guerrero.
Okay, can I go to mine? No, yeah, I was thinking about Article 12 specifically on the concept of blood quantum. I think it used to have, I believe it was amended and it's no longer there. But I believe that principle still stands in like Native Hawaiian communities in terms of ownership of land and also in Native American tribes in terms of tribal membership and how, initially how the law of Article 12 and other similar laws that were written before was a way, like, we know now that race is socially constructed, but in the letter of the law, we have to sort of give a numerical measure to identify someone as a particular race. And so when you have something that's socially constructed, with different cultural, you could say physical factors, but you try to make it into a number of some sort. The crossover isn't 100% complete, and it presents problems.
Thank you. What I heard you mentioned the construction of race through the lens of Article 12. One of the law review articles that I published in 2008 questioned whether Article 12 is about the construction of race, or is it about the construction of a political identity? And that question, race versus political identity, has yet to be addressed, right? We have in the next few slides, we can talk about what that means in the larger framework of what's the case of Rice versus Cayetano, in which the Supreme Court addressed a question of a 15th Amendment issue right to vote for certain Native Hawaiians, and whether they were considered to be a racial group or a political group. And in that case, the Supreme Court held that Native Hawaiians are not a political category, they're not a political group, which is different from the construction of American Indian tribes as federally recognized tribes. Those are American Indian nations, are political, have a political identity or political categorization. Native Hawaiians are constructed as a racial group, and so in the Supreme Court case of Rice versus Cayetano, a restriction on the basis of Native Hawaiian was struck down as in violation of the 15th Amendment. So with that framing of race versus political identity, where does the CNMI fit in? Where do Chamorros and Carolinians, or maybe even more specific, where does the term Northern Marianas descend as defined by Article 12? Is that a racial category or is that a political category? That is a question that has not been answered as yet definitively, right? There are arguments on both sides that one can make. And we're going to talk about that in class in a few days. Okay, so what are some of the issues and concerns in the Pacific Islands? And this is just a litany also of different issues that many other scholars and activists, some of whom in the room, have been able to have written about or talked about. Loss of sovereignty and protection of the right to self-determination, right? The very foundation, the creation of the Commonwealth presupposes the need to exercise the right to self-determination because of the loss of sovereignty that stemmed from the colonization of the Marianas. An issue here, as it is in many other U.S. territories and also in in the 50 states rather, focuses on indigenous people's rights. What does that mean? How do we protect the rights of indigenous people, and in particular their culture, customs, and way of life? American Samoa, there's an issue that I'll talk about next week regarding citizenship and how citizenship to them impacts their fear that acquiring U.S. citizenship will lead to the loss of their way of life, or some of the loss of their way of life. Land, Article 12, that land is a scarce resource in the Northern Mariana Islands and other places. And so an issue here would be how to protect land, right? Language. Language, how does one protect language and to ensure that people have the right to be able to speak their language in the workplace? Here in the Marianas, language rights are protected. One can speak Chamorro, Carolinian, and all the other languages in the workplace. In some places, that's not necessarily the case. And then, of course, governance. How do we ensure that not only in the Marianas, but in other Pacific islands, that the right to be able to govern oneself, self-governance, how can that continue to be protected? But it's not only indigenous people's rights that are at issue. There are, in a multicultural society that we live in, including here in the CNMI, there are non-indigenous peoples, right? Non-indigenous individuals, families who've lived here, who grew up here, and they have rights too. How do we balance the rights of non-indigenous people with the rights of indigenous peoples? Here in the Marianas, one question is whether there's meaningful representation in the United States. Congressman Zablon is our congressman, representative, but he, along with the other representatives, congressmen representing the other 4 U.S. territories, plus District of Columbia, do not necessarily have the same power and benefits as the representatives of the 50 states. And so one question becomes, how do we push for meaningful representation in Congress? And as mentioned earlier, the right to vote. Okay, so these are just some of the issues that many others have written about and talked about, and we won't have time to talk about all of them. I want to make sure that we have that we have enough time for Q&A. Okay, so let's just talk about Article 12 since that has been brought up. How do we apply Article 12 or apply CRT to CNMI law? And so here's the current definition of Article 12. Right? A person of Northern Marianas descent is a person who is a citizen or national of the United States and who has at least some degree of Northern Marianas Chamorro or Northern Marianas Carolinian blood, or a combination thereof, right? So some degree. Here this is long, but I know many of you are familiar with this, so I'll just highlight key points here. NMD, Northern Marianas descent, is defined as a person who is full-blooded at Northern Marianas Chamorro or Northern Marianas Carolinian if that person was born or domiciled in the Northern Mariana Islands by 1950. So we begin with 1950, where they're born here and domiciled here, right? And were they a citizen of the Trust Territory of the Pacific Islands, TTPI, before the termination of the trusteeship agreement. So when we look at the way that Article 12, NMD, has been defined, it brings us to the question of whether this is a racial category or a political category, right? We're not going to be able to come up with a satisfactory answer at this lecture, certainly not in the next 10 minutes. But I at least want to start throwing some suggestions or questions for you to think about so that we can continue to have a conversation about this. What was the purpose of Article 12? What was the goal, right? Article 12, as written in the Constitution itself, the CNMI Constitution, was done because in view of the importance of ownership of land for the culture and tradition of the people of the Northern Mariana Islands, and in order to protect them against exploitation and to promote their economic advancement and self-sufficiency. Okay, so that's the articulated purpose of Article 12. And by designing Article 12, or in passing Article 12, it was again designed to protect those who are NMD. Okay, so now we go back in time to a case that some of you are more than familiar with, and my students in this class will be reading in a few days. Waldo versus Villa Crucis. It was a 1992 opinion from the Ninth Circuit, and we're not going to go into detail about this in the interest of time. The central issue there is whether Article 12 violated the Equal Protection Clause, and the court said no. And here the court did not rely on equal protection jurisprudence. It relied instead on the insular cases doctrine. I know that there has been a lot of conversations recently here in the Marianas on the insular cases doctrine. And in class, students, don't worry, we're going to talk about it some more. The lawyers in the room already know, so I think we're all on the same page here. Here in the Waldo case, the Ninth Circuit said that applying equal protection would be impractical and anomalous in this setting, and so therefore upheld Article 12. The question then is what results if EPC, if Equal Protection Clause, applied? And here again, it depends on whether Article 12 is a racial or political category, right? If political, it may be upheld, right? Because here, as I mentioned earlier, the Supreme Court has upheld laws that were designed to protect political indigeneity, and specifically American Indian tribes. If it's a racial category, then it must satisfy strict scrutiny. And what does that mean? It means, and here's this test, it's a really difficult test to meet, but it's a test that in order for a law to pass, it must have a compelling government interest that is narrowly tailored to achieve that interest. In other words, it has to be really, really compellingly important in order for it to be upheld. Because race and racism are both, they occupy our American history such that when there is a categorization, a law that's passed on the basis of race, they almost always get struck down. We're going to watch out for the affirmative action case coming up. It'll be decided by the Supreme Court next year. And that is a one for higher education, but also in other contexts, it might have an implication for us here in the Mariana Islands. So if it's racial, might it get struck down? Perhaps, depending on the Supreme Court case next year. One that I would urge us to think about again is black and white binary. And what does that mean? That means that the history of equal protection law has primarily focused on the subordination of African American people by white elites. And so then the question becomes, where does the CNMI and other Pacific Islander populations fit in? Where would Article 12 fit in here? On the one hand, I think for non-Indigenous people who cannot own property, it feels as if it's race discrimination, right? You cannot own land here if you're not NMD. On the other hand, NMD individuals will argue this is supposed to protect us because of land is a scarce resource. And importantly, the Commonwealth might not have been able to become a Commonwealth because it was an important part of the negotiation for the covenant to protect land rights. So from that argument, one can see that it's a political one, right? On the other side, though, when it's framed along equal protection, one might see that it could be more of a racial category. And so it becomes, how is this about CRT? Why is the CRT? So we've been talking about Article 12 for quite some time now. Now CRT is, and I mean here in the CNMI since 1992, and then there are all these other issues regarding Article 12 that kept coming up and up. And now CRT, critical race theory, is in the news a lot, and there have been conversations about it. There is this an opportunity to revisit Article 12 and how we as a community can talk about its, what it means, its ongoing values, and how to ensure the goals of Article 12, but at the same time recognize that there are other people who have been excluded from owning property and what impact that might have on them and the future of the CNMI. And so in closing, as I'm seeing that I'm running out of time and I want to make sure that we have opportunities for questions, the point here that I wanted to make in general is to say that critical race theory is part of a movement to try to have a deep exploration of what the laws and regulations and policies, and to try to see how do those laws, regulations, and policies promote the interest of only one population at the expense of the other. And if we can see that there is racial subordination that is happening, whether explicitly or implicitly, then we must stop, we must pause, and we must engage and figure out what are we going to do about it. And so I hope that through this lecture, we can continue talking about Article 12 and other issues that are important to the people of the Mariana Islands. And so with that, I thank you, and I would love to just open up the time now for some questions. Anybody else but Dr. G? I'm kidding.
So earlier you said that one of the key tenets, and correct me if I'm wrong, of CRT is praxis, right? Translating all of this into some kind of practice or action. So it seems to emerge from academia and have clear implications for political action and legislation and the law, like writing the law itself. What might the implications be for practicing attorneys or jurists or judges and justices as they do their work?
Thank you. So outside of Article 12, I think lawyers to be judges and justices, have, in my own personal view, an obligation to examine further the history of laws and what impact they have had over time, and if it's within their power to engage in a correction, right, of some sort. One might argue that judges and justices are hampered by precedent, by stare decisis. That is a really challenging term these days from many different contexts, but the goal, the purpose of CRT is to challenge the status quo and examine what can be done in order to remedy any kind of ongoing subordination of people of color. Other questions?
Thank you very much, and this is a very interesting talk. I wanted to know if you could talk a little bit more about the idea of a social construct when it comes specifically to race. I wanted to know specifically if it conflicts with the idea of someone being born this way or born a certain race or.
Oh, that's great, because that's one of the branches of CRT that I think that needs to be developed further in the LGBTQIA+ context. And so there, on the one hand, society, right, laws of society construct who is raised, and that's based on whether it's blood quantum or color and or phenotype, right? And then on the other hand, there's also this acceptance or acknowledgement that one can choose to can choose to be different. And some might choose to be different, others might say that they're born that way, and that's who they are at the core of their identity. And so there needs to be better additional exploration and language to explore, for example, the concerns of trans individuals. But even, do you remember the Rachel Dolezal case? This is a white Jewish woman who identified as Black. She said that she's Black. And so then the question is, is that one, and is race also one that one can take up on their own? And there needs to be a deeper analysis even within CRT. Although there are, of course, others have already been exploring those issues. Ms. Hirsch?
I was just wondering, kind of along those lines of the definition. Along the lines of definition and identification with race, not even if someone says they're white but they identify as Black. For people like me who were adopted, and I was raised by a Chamorro Japanese family, I haven't gone through with taking the genetic test to see if I am indeed Japanese Chamorro, because there's sort of a pressure put on that once you kind of know what you biologically are, society seems to imply that you're no longer allowed to say what you were raised as, because you kind of have a duty to identify to others what you really are.
I think authenticity is important, right? And that is, being authentic is who you are, as opposed to what this DNA test says who you are, or what others say who you are. It won't matter, really, if you take a DNA test, in my mind, I don't think it should matter what you think, or what society thinks. It's just, it's a test. My response would be to focus on the authentic self. And only you will know what that means, right? And CRT challenges the status quo and challenges all the social, the prescription and imposition of race and gender and sexual orientation and all those different categories that society imposes on us. CRT says to push back and not care so much about things like those DNA tests. Having said that, it is important for others to know their origin, what their story is. And to them, that's important to know, because it gives them an idea or a path towards finding their roots and learning more about their ancestry, right? Learning more about their ancestors, grandparents, and where they came from. Yeah. Hi, Bruce.
Hi. Early in the lecture, you mentioned that it's often uncomfortable. And I've been sitting here thinking that you're describing a tool for exploring not just the intellectual issues, but self-exploration. Self-examination is never comfortable, nor do I believe it ever should be. And that's probably just what comes with the territory. And I think it's very worthwhile to develop these tools. I want to thank you for the lecture.
Oh, thank you. Thank you for being here. It's not, talking about race is not easy. You know, we almost want to, we have this nature of, don't want to rock the boat. We don't want to talk about that, anything that's uncomfortable. But if we're going to get past racism, we have to talk about it, right? And here in the Marianas, it means talking about not only about race, but also ethnicity, colonization, self-determination, immigration, citizenship. There's a whole host of factors that are all wrapped up. in who we are as a people in the Mariana Islands. So I hope that the lecture was useful to you and you're thinking about race and a path forward. I'm happy to stay here if you have any questions that you want to ask me that you don't want to ask in public. Thank you again for being here.
Thank you again very much to Interim Dean Villazor for coming out all the way here to speak with us and participate in the law program. Just a reminder, if you haven't filled out the survey yet, please do so. There are a number of pens on the tables over there. I'll be coming around 5 minutes. If you are interested, if you're a member of the Bar Association, if you want to claim a CLE credit, we have a sign-up sheet. Make sure that you've signed in. And also just a reminder, this is only the first of 4 planned public lectures. The next one will be this Thursday at 6 p.m. at American Memorial Park. The third one will be July 5th, also at 6 p.m. at the American Memorial Park. And the last one, July 7th, will be again here at Guma Hustisia at noon. Thank you all again very much for coming.